The man charged with killing Charlie Kirk is back in court. Here's what we can expect, and I'm also answering audience questions. Hi, I'm Melba Pearson, also known as the Resident Legal Diva, and this is a special edition of Ask the Diva. Make sure to like, comment, and subscribe to Legal AF for all things at the intersection of politics and law. So Tyler Robinson was back in court for a status hearing. Now, first off, gotta frame what's happening here. I will start with who is deserving of public outrage is subjective, but we are all entitled to justice. So yes, I want to see the Epstein files released. Yes, I want to see missing and murdered Indigenous women and Black women who have also been missing and murdered. I want to see their stories get closure. I want to see domestic violence victims get treated with the respect they deserve. But I also want to see justice in this case as well, whatever justice may be, because again, things are still unfolding, the evidence is still coming in, and there's a lot of questions that still need to be answered. So, Tyler Robinson, the person charged with the murder of Charlie Kirk, his attorneys have filed a motion, and basically some of the substance of the motion was, number one, they wanted him to be able to come to court in his civilian clothes. So as we know, this case has drawn a lot of media attention. At this juncture, there are still cameras in the courtroom. Apparently, that is another aspect of the motion. Defense attorneys do not want cameras in the courtroom for a variety of reasons, which I'll get into. So what was very interesting was that when the defense filed that motion, which again, that has several parts, including him wearing civilian clothes, etc., the prosecution, which is led by the Utah City Attorney, responded. And then the defense had a huge problem with the prosecution's response. Why? Because they say the motion sounds like it was written by the sheriff's office. So, the sheriff's office is a witness in the case because they've led the investigations, they helped lead the arrest of Tyler Robinson and all of that. So yeah, they are an interested party in the case. However, they are not a party to the case. So in other words, it's the state of Utah. So that would be represented by the Utah City Attorney's Office. And there's Tyler Robinson as the defendant and his counsel representing him. Nobody else gets to be in the mix. So if the sheriff's office has a concern about the case, they say what they have to say to the prosecutor includes that in their motion. But when you have the defense saying that the prosecution is literally cutting and pasting from whatever correspondence or anything coming from the sheriff's office, that's a problem because you have to have independence in each of the lanes that are involved in a criminal case. The judge has got to be independent. So they've got to be free from political pressure or anything to make the right decisions following the law, right? The prosecution can't be focused on all this other foolishness. They need to be focused on what's the law, what evidence do we have, and can we prove this case beyond a reasonable doubt? And the defense obviously has to worry about making sure that Tyler Robinson's constitutional rights are not violated, that he gets a fair trial, and that if there's any exculpatory evidence or evidence that shows he's not guilty, make sure that that's been uncovered and gets brought to light and gets in front of the judge and jury for them to be able to make a full decision. So in all of this, the sheriff's office is basically in the realm of law enforcement, prosecution. So again, the prosecution is the one that's leading that entire effort. So the sheriff's office should not be dictating what happens to any part in this case. They can have an opinion like any other witness or like the next of kin. Everybody's like, oh, I want to see this happen. All fine. But the prosecutor has to cut through all that noise and figure out what's best for this case, not parrot what somebody else said, right? So as part of this motion, the defense's response to the prosecution's response to their motion, right? So remember, defense filed a motion saying they wanted the defendant to be able to wear civilian clothes. They didn't want cameras in the courtroom, a couple other things, because again, we have not seen the motion in full. Prosecution responds. Likely, my guess, it has to do with the fact that the sheriff's office also runs the jail. So they may have some security concerns in terms of whether or not Tyler Robinson should be able to wear his civilian clothes or have to come in shackles and in prison clothes, right? So you can see why they may have a concern. But again, that concern should be given to the prosecution. So anyway, in the defense's response to the prosecution's motion that sounded like it was written by the sheriff's office, they said the following: as stated by our professional rules of conduct, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice and that guilt is decided upon the basis of sufficient evidence. It is not appropriate for the attorney's office, the prosecution, to assume a role as counsel for the sheriff's office and allow the sheriff's office to assume standing through the attorney's office's participation as a party in this case. So again, bottom line here, prosecutors have a very separate ethical obligation than that of defense attorneys or anybody else in the system. Again, prosecutors can't talk about the case, which is why Kash Patel running his mouth was problematic, because again, law enforcement in these types of cases, they stay silent, right? They let the evidence speak for itself, or they speak in the court of law, right? So that's generally how this is supposed to go. So you have that aspect. And prosecutors also, again, have to look at the totality of the evidence and can't necessarily rep any one party. Because I'll give you a quick story from me as a former prosecutor. There are times when the victim or the victim's family in a case want one set of action. They want, let's say, life on a case where the maximum penalty is 25 years in prison, let's say, right? And you have to, as a prosecutor, have to tell them, hey, this doesn't work with the law. This doesn't make sense in light of the law. We can't get that for you. Understand that you have strong feelings about this, but I think a more appropriate resolution is 10 years. And then sometimes a victim gets really upset, right? But again, it's your duty as a prosecutor to seek what's right and do what's right in a case. Obviously, you're going to want to do your best by victims of crime, next of kin, survivors of crime, that sort of thing, right? But you also have to balance that with what is just, what the evidence says, what the law says. And when you're not doing that, it's a problem. So I've had to deal with that struggle. And you just figure out a way to, number one, be very communicative, explain to them what is realistic and what is not, and try to kind of, diffuse the situation. You don't just run in there and say, well, the victim wants this, so that's all we're going to do. That's the formula for disaster, right? So in this particular instance, even though the sheriff is not a victim, they're a witness, prosecution can't cut and paste what the cops say to do. They got to make their own decisions. So there's that. Now, one of the key things about this motion and the wearing of civilian clothes is because now that Tyler Robinson has an attorney, they're thinking about pretrial publicity. So they know at this point there's cameras in the courtroom. They're hoping to get that changed in the near future because they don't want this whole thing to be televised for a number of reasons. And back and forth on that one. So, talking about pretrial publicity, at least now, moving forward, when the public sees Tyler Robinson, they see him in street clothes. The defense wants to make sure that he is cloaked in the presumption of innocence. Because again, in the United States, you are innocent until proven guilty. So by giving the person the perp walk and they're in shackles and they're always in prison clothes every single time you see them on television, who else is watching on television? Your jury pool, the people who you're going to select the jury from, right? So if they're looking at all of this programming over the course of a year, 2 years, however long it takes to get to trial, they're going to be programmed and they're going to keep seeing this person. They're guilty. They're in prison clothes already. They have to be guilty. If they're being shown like this, they must be guilty, right? And it ends up being very subtle, because again, you're seeing this and it becomes normalized. So when you get to court as a potential juror, you're like, oh yeah, I can be fair and impartial. But already in the back of your mind, because of all you've been seeing, you think that this person's guilty. So that's a problem. Now, a number of you have been asking questions around change of venue and how to make sure that the jury pool isn't tainted. This is one of the ways, right? Making sure that the defendant appears as a regular person, not as somebody who's in custody. So that's important. Now, the defense doesn't want the trial to be publicized and all of the hearings, because again, there's going to be a ton of hearings before we get to trial. This is not, Law and Order or whatever, where bing, bam, boom, person's arrested and you go to trial the next month. No. In the U.S. criminal justice system, cases take a while. So knowing that there's going to be a bunch more hearings, obviously they want their person to appear as regular as possible, right? So that's an important part of it. Now, in terms of the change of venue aspect, a lot of folks have been asking about that. There's going to be a case to be made for a change of venue, and I think the judge will grant it. Reason being that it's going to be highly unlikely that the court will be able to get a fair and impartial jury from the immediate county where this happened in, because this is something, again, that was high profile. It was in the news all the time. Folks remember the manhunt in looking for the shooter. So all of this was super intense and was in everybody's face. So people already are going to have an opinion. And the issue is, can people put aside that opinion and listen to the evidence that's in the courtroom and render an opinion based on that evidence, not based on what you saw on television, not based on what you heard, not based on what your friend them say, none of that. It has to be what's in front of you in court. And if emotions are running too high, then it is impossible to pull an impartial jury from that area. So I think it will end up probably getting moved a county over. Now, here's the other danger. This is a case that has national attention. So of course, everybody everywhere would have heard about this case. So that's not to say that moving this case to another jurisdiction is going to give you a completely impartial jury. No, but you have a better shot at getting an impartial jury because of the fact that it wasn't on the ground, like people were hearing helicopters overhead and seeing, police cars driving up and down the block and folks locking their doors because they're not sure if this is someone who's, a random shooter on the loose type of thing, right? They don't have that same palpable, oh crap, I watched it unfold in real time. So that gives a better chance at having an impartial jury than having the trial in the place where the crime actually was committed. So there's that. So I think he's going to be moved. And someone else also asked the question regarding why is it going to take so long to come to trial? Why do I think it's going to be a year and a half? Well, first of all, the evidence is still coming in. Think about how many people were present for the shooting. Both sides are going to want to interview all of them because they're going to want to see, hey, is there any discrepancies or differences in what people saw? What did you see from your vantage point? These are all things that once you get all of their testimony, then you're going to want to follow up things that they've said, whether it be to protect your client and to show that he didn't commit the crime, or from the prosecution's perspective, to show conclusively that Tyler Robinson is the person that committed this crime beyond a reasonable doubt. So the investigation is still ongoing. I know folks may be making it seem in the media that it's done and dusted and it's a wrap up. No. In every case, and I've handled a ton of homicide cases, right? Deep double digits. This is something I know backwards and forwards. The investigation can last literally up until the day before trial because there might be one little detail that popped out because you're talking to a witness, propping them before trial, and boom, they said something like, oh, you never said this to anybody before. Oh, I got to follow up on this, right? So these types of things happen regularly. So the investigation isn't over. So again, that's going to prolong how long it takes for this case to come to trial. Also, there's something called depositions. Not every state has them. Florida's one, but there's several other states that have it as well. But basically, it's part of what we call the discovery process. It's the time when the prosecution has to turn over everything they're going to rely on at trial to the defense. And the defense has a right to figure out and talk to witnesses and figure out, what are you going to say at trial? And based on what you're going to say at trial, I'm going to now plan my defense of Tyler Robinson. That's not something that happens overnight. Again, you're thinking about just looking at the sheer number of people that were present, but we're not talking about the amount of law enforcement that were involved in the investigation and finding out what each of them saw, what they worked on, whoever handled ballistics, the coroner, right? Because there's a whole bunch of questions y'all have posed about the autopsy and all of that. And I'm going to do a separate video on that coming up next. So stay tuned for that. But you got to have the medical examiner come in, or the coroner, explain the process by which they came to the conclusion that this was a homicide. All of that. This doesn't happen overnight. And so the defense has to talk to all these people. That's going to take time. Trying to get everybody's schedules together, that's going to take time. So it is not unusual for homicide cases in the US to be at least 18 months or to 2 years for it to come to trial. Sometimes longer. I've seen as many as 5 or 6 years. It all depends on how swamped the system is in terms of how many homicide trials are in the pipeline ahead of them, etc. But with this being such a high profile case, I anticipate it'll be expedited, which is why I say 18 months to 2 years. All right, so that's the story of what's currently happening in the Tyler Robinson case, the person charged with the murder of Charlie Kirk. I'll be back to dive into your questions about the autopsy. Please be sure to weigh in the comments with any questions that you may have. Happy to answer them from a former prosecutor's perspective, and stay tuned for more. I'm Melba Pearson, also known as the Resident Legal Diva, and this was Ask the Diva. Stay safe, stay informed, and keep demanding justice. Take care.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.